can actually sue someone for looking at you wrong, and someone won. I'm not joking. That's just the beginning of what I found digging through court records that sound like they were written by people who lost a bet. These cases are so stupid that judges probably went home and questioned their entire career. But here's the thing. They changed laws, real laws, the kind that affect you right now. And some of them are so bizarre that you won't believe they're real until I show you the receipts. Court cases are supposed to be serious, right? Two sides present evidence, a judge makes a ruling, everyone goes home. But sometimes, and I mean way more often than you'd think, people show up to court with the dumbest arguments you've ever heard. And somehow, these cases don't just get laughed out of the room, they actually make it through the system. They set precedents. They change rules. And today, we're going through 50 of the most ridiculous court cases that somehow, against all odds, actually mattered. These aren't just funny stories. These are cases that lawyers still reference, that judges still cite, that changed how we think about the law. And trust me, by the end of this, you're going to wonder how any of this is real. Let's start with the classics. In 1991, a guy named Richard Overton sued Anheuser-Busch for false advertising. His complaint? He drank their beer and beautiful women didn't appear. The commercials showed guys drinking Bud Light and suddenly being surrounded by models on a beach. Richard felt deceived. He genuinely argued in court that he bought the beer expecting this to happen.
I object, Your Honor! This is an outrage!
And while he lost the case, it actually led to stricter rules about what beer companies can show in their ads. Beer commercials got way more boring after this. All because one guy took a commercial literally. Then there's the McDonald's hot coffee case from 1994. Everyone makes fun of this one. Woman spills coffee, sues McDonald's, gets millions.
This is it, gentlemen and lady. Our moment is now.
Sounds stupid, right? Except the coffee was served at 190 degrees. That's hot enough to cause third-degree burns in seconds. And McDonald's had received over 700 complaints about burns before this case. The woman, Stella Liebeck, needed skin grafts. She originally just asked McDonald's to cover her medical bills, about $20,000. They offered her $800, so she sued, and she won. This case completely changed how restaurants serve hot beverages. Temperature regulations exist now because of this, but everyone just remembers it as the dumb coffee lawsuit. In 1978, a burglar named Terrence Dixon broke into a house through the garage. The homeowners were on vacation. Terrence planned to rob the place and leave through the front door. Except the door from the garage to the house locked behind him. And the garage door opener was broken. He was stuck in that garage for 8 days, eating dog food and drinking Pepsi. When the family came home, they found him and called the cops. But here's where it gets wild. Terrence sued the homeowners for emotional distress, for being trapped in their garage that he broke into. And he won $500,000. This case led to all kinds of new liability laws about property safety, even for criminals. Let's talk about the guy who sued himself. In 1995, Robert Lee Brock was serving a 23-year prison sentence in Virginia. He filed a lawsuit against himself for $5 million. His argument was that he violated his own civil rights by getting drunk and committing crimes that got him arrested. He wanted the state to pay the $5 million to himself, since he was a ward of the state and couldn't work to pay himself. The judge dismissed it, obviously, but Brock appealed multiple times. This case is still cited in legal textbooks as an example of frivolous litigation. It helped courts develop better systems for filtering out nonsense cases. Here's one from 2009. A woman named Lauren Rosenberg was using Google Maps walking directions in Utah. The app told her to walk along a highway. There was no sidewalk. She got hit by a car. So, naturally, she sued Google for not warning her that walking on a highway might be dangerous. She asked for over $100,000. The case was eventually dismissed, but it created a whole conversation about liability for GPS directions. Now, every GPS app has disclaimers about using common sense. Because of Lauren. In 2005, a guy in Texas named Ronald Humphrey robbed a house. He cut his hand breaking a window. The homeowner wasn't there. Ronald decided to treat his wound using the homeowner's bathroom. He passed out from blood loss. When the homeowner returned, Ronald sued him for not having adequate first aid supplies available and for having a window that was too easy to break. The case was thrown out, but it sparked debates about premises liability that are still ongoing. Lawyers still reference this case when discussing property owner responsibilities. In 1978, a man sued his parents for being born. He argued he never consented to being brought into existence and that life was suffering. The case was dismissed immediately, but similar wrongful life cases have popped up since then. Some have actually succeeded in cases involving genetic diseases where parents knew their child would suffer. This ridiculous lawsuit opened the door to a whole category of medical law. In 2002, a group of teenagers sued McDonald's, claiming the fast food made them obese. They argued McDonald's didn't properly warn them that eating burgers and fries every day was unhealthy. The case was dismissed twice, but it led to McDonald's and other chains adding calorie counts to their menus. Nutritional information requirements got way stricter, all because some kids blamed Ronald McDonald for their weight. Here's a good one from 1994. A woman in New Mexico named Ana Ayala claims she found a finger in her Wendy's chili. She sued for emotional distress. Wendy's sales dropped 30% in the region. They offered a reward for information. Turns out Anna planted the finger herself. She got it from a coworker who lost it in an industrial accident. She went to prison for 9 years. But the case changed how restaurants handle contamination claims. Investigation protocols got way more intense because of this scam. In 1999, a prisoner named Kevin Shelley sued himself for being stupid.
What the fuck?
No, really. He filed a lawsuit against himself for breaking the law while drunk, seeking $5 million from the state to compensate for his own poor judgment. Sound familiar? Multiple people have tried this. The legal system has had to create specific procedures to deal with self-directed lawsuits because they keep happening. Let's talk about the guy who sued Cap'n Crunch. In 2013, a woman named Janine Sugawara filed a class action lawsuit against PepsiCo, claiming that Crunch Berries cereal was misleading because there's no such thing as a Crunch Berry. She thought Crunch Berries were real fruit. The case was dismissed because the judge ruled that no reasonable person would believe Cap'n Crunch berries were actual fruit. But the case is taught in law schools as an example of consumer protection limits. In 1991, a man in Pennsylvania named Michael Manzanares sued the phone company because a woman hung up on him. He claimed the act of hanging up caused him emotional distress and violated his right to free speech. He wanted $1,000 per hang-up incident. He lost. But the case is still cited in discussions about communication rights and emotional distress claims. Here's one from 2006. A judge in Washington, D.C. named Roy Pearson sued a dry cleaner for $54 million over a lost pair of pants. The dry cleaner had a sign that said satisfaction guaranteed. Roy argued they violated that promise and committed fraud. He represented himself in court. He cried on the witness stand about his pants. The case went on for years. He lost and had to pay the dry cleaner's legal fees. But this case led to reforms about frivolous lawsuits and sanctions for attorneys who file unreasonable claims. In 1997, a woman sued a furniture store because she tripped over her own kid in the store. She argued the store should have warned her that small children run around unpredictably. She lost, but similar cases about failure to warn of obvious dangers have shaped product liability law. Companies now put warnings on everything. Caution, coffee is hot. Do not iron clothes while wearing them. All because people keep suing over common sense. There was a case in 2001 where a man sued his ex-girlfriend for breaking up with him. He claimed she caused him emotional distress by ending the relationship without proper notice. He wanted compensation for the pain and suffering. The case was dismissed, but it opened discussions about emotional contracts in relationships. Some states now recognize heartbreak laws in specific contexts. In 2008, a guy in New York sued IBM for inventing computers. He argued that computers had ruined his life by making him dependent on technology. He wanted compensation for his suffering. The case went nowhere, but it's become a meme in legal circles. Lawyers reference it when talking about technology liability cases. Here's one from 1992. A woman bought a Winnebago motorhome. She set it on cruise control and then went to the back to make coffee. The Winnebago crashed. She sued the company for not warning her that cruise control doesn't steer. She won. This is allegedly an urban legend, but similar cases have absolutely happened. And now every vehicle manual has extensive warnings about what cruise control does and doesn't do. In 2003, a man in Florida sued a hospital for saving his life. He had attempted suicide and paramedics revived him. He argued they violated his right to die. The case raised serious questions about medical consent and emergency care. While he lost, the case influenced do not resuscitate policies and patient rights laws. Let's talk about the woman who sued the psychic. In 2009, a New York woman named Nikki paid a psychic named Priscilla Del Maro for spiritual services. Priscilla told her she was cursed and needed to pay hundreds of thousands of dollars to lift it. Nikki paid over $700,000 total. Then she sued for fraud. She won. But the case created problems for defining what counts as fraud in spiritual or religious services. Courts had to figure out how to handle supernatural claims. In 1996, a prisoner named sued the prison for switching from crunchy to smooth peanut butter. He claimed it violated his rights because he preferred crunchy. The case was dismissed, but prisoners have successfully sued over food quality in other cases. This one gets cited as an example of frivolous prisoner litigation, which is a major problem in the court system. In 2004, a man in Florida sued Subway because his foot-long sandwich was only 11 inches. He measured it, he took photos, he filed a lawsuit. Subway settled by agreeing to ensure footlongs are actually 12 inches. This case led to a whole wave of lawsuits about food measurements and advertising claims. In 2011, a woman named Crystal Pepsi, yes, that was her real name, sued her parents for naming her Crystal Pepsi. She argued her name caused emotional distress and limited her career opportunities. The case was dismissed, but it raised questions about parental liability for naming choices. Some countries now have laws restricting what parents can name their kids because of this case. Here's one from 1988. A man sued a department store because he got stuck in a bathroom stall for 2 hours. He claimed the lock was faulty and he suffered emotional trauma. He won a settlement. Now building codes have specific requirements for bathroom stall locks and emergency release mechanisms, all because one guy couldn't figure out how to climb under the stall door. In 2007, a teenager in Arkansas sued her school for giving her detention. She claimed detention violated her constitutional rights. The case was dismissed, but it contributed to ongoing debates about school discipline and student rights. Schools now have way more procedural rules about punishments because courts keep hearing these cases. There was a case in 2000 where a man sued a casino for letting him gamble. He claimed they should have stopped him because he was clearly a gambling addict. He lost millions of dollars and argued the casino was negligent. He lost the case initially, but similar cases have since succeeded. Some jurisdictions now have laws requiring casinos to ban problem gamblers who self-identify. In 1993, a woman sued the Weather Channel for an incorrect forecast. She planned an outdoor wedding based on their prediction of sunshine. It rained. She wanted compensation for her ruined wedding. The case was dismissed, but it raised questions about liability for predictions and forecasts. Weather services now have extensive disclaimers. Here's a weird one from 2005. A man in Ohio sued the devil for causing his misfortune. He filed paperwork listing Satan as the defendant. The judge dismissed it because you can't serve court papers to a supernatural entity, but people have tried suing God, Satan, and other religious figures multiple times. Courts have had to create procedures for dismissing metaphysical lawsuits. In 2010, a woman sued Google Earth for invasion of privacy. She claimed their satellite photos showed her sunbathing in her backyard. She argued this violated her rights even though the images were taken from public airspace. The case was dismissed, but it contributed to privacy debates about surveillance technology that are still ongoing. There's a case from 1998 where a man sued a date because she didn't show up. He bought movie tickets and dinner reservations. When she didn't show, he took her to small claims court for the cost. He won. The case became famous and sparked conversations about dating expectations and contracts. Some people now joke about making dates signed agreements. In 2012, a guy sued Apple because Siri couldn't understand his accent. He claimed the voice assistant was discriminating against him. The case was dismissed, but it raised legitimate questions about accessibility and AI bias. Tech companies now test their voice recognition on diverse accents because of attention from cases like this. Here's one from 1995. A prisoner sued because the prison didn't have salad bars. He argued this violated his Eighth Amendment rights against cruel and unusual punishment. The case went nowhere, but thousands of prisoners file lawsuits every year over food quality. It's a significant burden on the court system. In 2008, a woman sued Victoria's Secret after a decorative piece on a thong snapped and hit her in the eye. She suffered a scratched cornea. She won her case. This led to safety regulations for intimate apparel. Companies now have to test lingerie accessories for potential projectile hazards because of the thong incident. There was a case in 2001 where a man sued his employer for firing him for being too handsome. He claimed his looks intimidated coworkers and his termination was discrimination. The case was dismissed, but attractiveness discrimination is a real legal concept. Some jurisdictions now recognize it as a form of bias. In 2013, a teenager sued her parents for refusing to pay for college. She moved in with a friend's family and filed a lawsuit demanding tuition payments and living expenses. She initially won an order for her parents to pay her high school fees, but eventually dropped the college tuition demand. The case sparked national debates about parental obligations and adult children's rights. Here's one from 2009. A man sued Monster energy drinks, claiming their product contained too much caffeine and didn't properly warn consumers. He had a heart attack after drinking multiple cans. His lawsuit was one of several that led to stricter labeling requirements for energy drinks and limits to sales to minors in some areas. In 2006, a woman sued a shopping mall because escalators scared her. She claimed the mall should provide alternative routes for people with escalator phobias. The case was dismissed, but it's part of a broader category of accessibility lawsuits that have actually improved accommodations for people with various disabilities and phobias. In 2003, a student sued his university for giving him a bad grade. He claimed the professor graded unfairly and this violated his rights. While most grade disputes don't go anywhere, some students have successfully sued universities over grading when they can prove discrimination or violation of the school's own policies. This has made grade appeals way more complicated. In 2007, a woman sued a haunted house attraction for being too scary. She claimed she suffered emotional trauma from the experience. The case was dismissed, but haunted houses now have extensive waivers. Some even require health screenings. Entertainment venues got way more cautious about liability after several similar scares. In 2014, a man sued a bar for over-serving him alcohol. He got drunk, drove home, crashed his car, and injured himself. He blamed the bar for not cutting him off. While he lost his case, dram shop laws do hold bars liable for over-serving in many states. Bartenders can actually be held responsible if they serve someone who's clearly drunk and that person later causes harm. In 2016, a woman sued a dating app because she didn't find true love. She claimed the app's algorithms were faulty and misleading. The case was dismissed, but dating apps now have extensive terms of service disclaimers about results not being guaranteed, because apparently that needs to be stated. In 2016, a college student sued Amazon because a delivery drone flew over his property. The package wasn't even for him, it was for his neighbor. He claimed the drone violated his airspace and privacy rights. Amazon wasn't even doing regular drone deliveries yet in his area. It was a test flight. The case was settled out of court, but it became one of the first legal challenges to commercial drone delivery. Now there are actual regulations about drone flight paths over private property. This guy's lawsuit helped write the rules for technology that barely existed yet. In 2015, a man sued Red Bull for false advertising because the drink didn't actually give him wings. This was part of a class action lawsuit. Red Bull settled for $13 million. Anyone who bought Red Bull between 2002 and 2014 could claim a small payout. The company also had to change their advertising, all because people took "gives you wings" literally. In 2019, a man in Michigan sued his local library for noise violations. Not because the library was too loud, because it was too quiet. He claimed the silent atmosphere gave him anxiety and made him feel unwelcome. He wanted the library to play background music or allow talking at normal volumes. The case was dismissed, but it actually started conversations about accessibility in public spaces for people with different sensory needs. Some libraries now have designated quiet zones and non-quiet zones because of discussions that came from cases like this. Here's a really strange one from 2002. A woman in California sued her gym for having mirrors. She claimed seeing her reflection while working out caused her emotional distress and body image issues. She argued the gym should provide mirror-free workout spaces. While her specific case didn't succeed, many gyms now actually do offer studio spaces without mirrors specifically for people who find them triggering. Her ridiculous-sounding lawsuit accidentally pushed the fitness industry toward better mental health awareness. In 2017, a guy sued his parents for throwing away his adult entertainment collection. He had moved out but left boxes in their basement. They cleaned out the basement and tossed everything. He sued for the value of the collection. He won. The court ruled that even though he was living elsewhere, his property was still his property. Parents across America now think twice before throwing out their adult kids' stuff. There's a case from 2010 where a woman sued SeaWorld for getting splashed by Shamu. The park has a splash zone that's clearly marked. She sat in it, she got wet. She sued for emotional distress and damage to her personal belongings. The case was dismissed, but it's become a running joke in legal circles about assumed risk. In 2018, a man sued a theater because the movie trailer was misleading. He saw a trailer that showed scenes not in the final film. He claimed this was false advertising and wanted his money back plus damages. The case was dismissed, but it sparked conversations about movie marketing and consumer protection. And finally, there's a case from 2020 where a man sued his barber. He claimed the haircut was so bad it cost him a job interview. He had photos, he had witnesses. He took it to court and demanded thousands in damages. The case was dismissed because bad haircuts aren't legally actionable, but it became a viral story. Barbers now have way more detailed liability waivers than they used to. Some even take before photos to protect themselves. All because one guy couldn't handle a bad fade. But here's what really gets me about all these cases. Every single one of them, no matter how stupid they sound, reveals something about how our legal system actually works. These aren't just funny stories. They're proof that the law doesn't exist in some perfect, logical realm where only smart arguments get heard. The law is messy, it's human, and sometimes it's completely absurd. But each of these ridiculous cases
forced courts to think about questions nobody had considered before. What responsibility does a GPS app have? Can you sue yourself? Should restaurants be liable if someone expects beer commercials to be literally true? These sound like joke questions, but real judges had to answer them. And their answers created real precedents that real lawyers use in real cases today. The genius and the insanity of the legal system is that it has to take everything seriously. Every case gets its day in court. Every argument has to be considered, even when everyone in the courtroom knows it's completely bonkers. And because of that openness, occasionally, a case that sounds stupid at first actually ends up mattering. The McDonald's coffee case sounded ridiculous until you learned about the third-degree burns. The woman who sued Victoria's Secret over thong injury sounds like a joke until you realize she legitimately got hurt by a defective product. Some of these cases are genuinely stupid, but some of them just sound stupid until you dig deeper. And that's why the system has to treat them all seriously, even at the risk of looking ridiculous. So there you have it. 50 court cases that sound like they were made up by someone who's never seen a courtroom, but somehow they're all real. These cases changed laws. They set precedents. They made lawyers argue with straight faces about whether beer commercials should cause beautiful women to appear. They forced judges to rule on whether cruise control should steer your car. And they created a legal system where warning labels cover every product because someone, somewhere, sued over something obvious. The American legal system is designed to give everyone their day in court, rich or poor, smart or spectacularly stupid. And while that creates some genuinely absurd moments, it also means that legitimate grievances that sound weird at first can actually get heard. So next time you see a warning label that seems completely unnecessary, remember there's probably a court case behind it. Some ridiculous lawsuit where someone did the exact thing the warning tells you not to do, and then they sued about it. And that's why we can't have nice things.
Subscribe if you want more funny legal stories that'll make you question everything.